Mr. Wiltz would be one being held.
You said who? Which defendant was that?
Mr. Wiltsey, but I missed what he said.
Well, okay.
The whole, yeah, going to be a competency responsibility, so that you cannot, that will be held today.
We're trying to find an extra scanner for Andrew. For Andrew? So I'll keep one scanner and one signature. I don't think so. Right.
They're in the breakout room, so just let me know when they get back.
In Liz's email to me, she said to have you sign the dispo on. Mr. Did you see that anywhere? I don't know where I'm supposed to find it.
Signed.
Oh, okay, okay. And then the other, there was no service on this Kilbourne LT case at 11:15, so that's off the docket as well.
Okay. Yes.
Might have to close that breakout room. I think the jail's probably stuck in it.
I think that, okay, it takes about a minute for them to come back, and I don't know why, but we have been finding it takes like a full 60 seconds. But
Yeah.
I will let the judge know we're ready.
Okay.
I think we are ready, Judge Cooney. Mr. Connolly suggested you may have to close the breakout room to get the jail back.
Yeah. Okay. All right, this is People versus Leroy Herp, file 213081SM. And Mr. Herp is here with his attorney, Mr. Connolly. Mr. Roster is here for the people. And this is a bond hearing. So, Mr. Connolly, have you discussed this with your client, and what does he wish to do today?
Yes, Your Honor. Thank you. I discussed the matter with Mr. Herp. He wishes to admit that he had contact with the alleged victim in the case, which is a bond violation. He's also asking that Your Honor, we're requesting that Your Honor either revoke his bond or instate some sort of a cash bond so that he's getting credit while he's sitting in the Kalkaska jail. I believe he'll be in the Kalkaska jail for a while, Your Honor, so I want to make sure he's getting credit on this matter.
All right. What's he in Kalkaska jail for?
He has a felony possession matter.
Ah, okay. All right. Mr. Roster, any objections to that?
No, Your Honor.
All right. So we'll go ahead and cancel bond at this time. And that way, at least the defendant will be receiving credit. And is there anything else we need to take up on that matter?
No, Your Honor.
All right. So let's see. Next up is Rehan E at 8:50. Mr. Herp, you can let the corrections staff know that you're all set for this morning, okay?
Yes, sir. Thank you.
Yeah.
And Your Honor, there was a status conference for Mr. Fuller. It says 1 a.m. on the docket, but I don't know what time the court was going to hold that. That's a case that's pending competency and responsibility reviews.
Oh,
What's the last name again?
Fuller?
Do you have a first name, Mr. Connolly?
Oh, of course, it's on my phone. Jim, do you know? Timothy, yes. Okay, sorry.
yeah, I don't see it on my docket, so maybe it's already been taken off.
Okay, just wanted to clarify. Thank you.
Yeah. Hang on a second, though. Miss Stocking's checking to see.
Okay.
where it's at.
It is set for a status conference, which of course would not be on the judge's calendar. It would be on a calendar because those are not done. The status conferences are held kind of like pre-trials, right?
Yeah.
Between the prosecutor and you.
Oh, well, if it's set for a status conference, though, that's something that we do in court because I want to know what's going on.
Okay, so it is scheduled for 1 a.m. So I'm not really sure that we should expect Mr. Fuller. But we can get that reset.
Okay, but that is the status, just so Your Honor is aware that the Forensic Center hasn't conducted the reviews yet.
Well, I guess in that case, I'm not sure why it would be set for a status conference at this point, unless it was to review bond or something like that. I don't know. Is it jail?
It might have been an error, Your Honor. When I got the notice, I thought it was unusual, so I just wanted to bring it up.
So the notes in the Register of Actions say that it's set for a status conference, and she set it for a month in advance, just as a way to keep it scheduled to check on the progress of the case. So I can just let her know to, I guess I don't.
Yeah, I would just tell her to, maybe that's what she does to make sure that we're not getting a report and somehow it gets missed and we don't set it for a hearing. So if that's what she's doing, that's fine. But there's no hearing today is the main point.
Yes, Your Honor.
All right. Thank you, Mr. Connolly. Like a no-show on this case, so All right, well, let me know if she shows up.
I will
or
do that. Otherwise, we,
Sentence at 9.
9:00. Okay. How are you?
You filling in for Tammy?
I am.
This is Antrim, you know.
It is an Antrim day. Mm-hmm.
You want to see?
You're gonna hang out with Tammy.
Yeah.
Okay, sounds good.
Have fun.
Thank you. Have a good day.
Does this one have the new stuff yet?
No, it starts tomorrow. Judge Cooney, do you have your docket in front of you?
So anyone?
Oh, well, this is the first I've seen of a real person. Hi, Miss Claxton.
Hello, how are ya?
Good. Is Mr. Richards present?
Ah, there he is.
Yes.
Yes, he is. Okay, good. All right, good morning. This is file 202944FY, People versus Kyle Allen Richards, and Ms. Claxton is here on the defendant's behalf. And let's see, Mr. Roster is here for the people. And have you had an opportunity to go to the pre-sentence report with your client, Ms. Claxton? And is it accurate and complete?
Your Honor, we have reviewed the pre-sentence investigation report. We don't have any factual errors to correct.
Okay. Mr. Roster, anything for the people?
Just prior to imposition of sentence, I would like to inquire as to the payment of restitution. If it's been paid.
Okay. All right. And I take it the victim is not present today?
Correct. He's not going to, doesn't want to address the court.
Okay. All right. So Ms. Claxton, what would you like to say then on behalf of Mr. Richards?
Thank you, Your Honor. Your Honor, as the court can see, Mr. Richards has no previous criminal history. I think that speaks a lot to his character. He is a veteran of the National Guard for 6 years. He is very remorseful for what happened in this case. I think most importantly, he is prepared to make that restitution payment today. He wasn't able to, it's his understanding that the court wasn't able to accept that restitution prior to sentencing. So prepared to drive to the courthouse today to make that payment in full. Considering all of that, I think that the recommendations outlined in the pre-sentence report are appropriate. We would ask that the court follow those recommendations.
You said he's going to drive to the courthouse today and drop off a check.
That's correct, Your Honor.
The court's open for it, right?
It is.
So, okay. All right. All right. So, Mr. Richards, is there anything you'd like to say before I sentence you?
I would just like to say that I'm sorry for everything that happened. I am very sorry for the things that took place, and I'm just looking forward to paying back what I owe and moving forward. I know it's in my pre-sentencing. I am no longer in that line of work. I took a better line of work, and I look forward to seeing where life can take me from here.
Okay, thank you. And Mr. Rossiter, what would you like to say on behalf of the people?
I hope Mr. Richards has learned a lesson from this, and I think the victim was rather understanding in being amenable to a misdemeanor resolution condition upon the payment of restitution, because this wasn't just over the threshold of $1,000. This restitution was $13,000. So, but I guess I would like to, I'm skeptical, just I guess by nature of seeing defendants come through and hearing what is going to take place. If Mr. Richards doesn't pay restitution today, I would reserve the right to file a motion to withdraw the plea. But I think that the problem with that would be once sentence is imposed, so I guess I would ask that this be a conditional sentence until the restitution is in the court's hands.
Okay, well, I guess I'm not sure where the information came from that restitution could not be made until the date of sentencing.
Because there's no way for the court to take the payment.
Because it has to go through the court.
Mm.
All right. All right, because based on the victim's letter here to the court, Mr. Richards has been dishonest about everything about this transaction involving $13,242. In fact, he says, I've never encountered anyone as creative as Kyle on avoiding telling the truth. So the checks in the mail isn't real satisfying, but under the circumstances, since the court would not accept the payment, and since we're under COVID restrictions, what I'm going to do is I'm not going to take any chances on this. I'm just not going to sentence Mr. Richards today, but we are going to accept the payment. I want to get a copy of the check, and yeah.
Can you order the payment of the restitution so we can put that in the system to accept the check?
I'm just going to order today that the court will accept the check as restitution, and then we'll set sentencing for the next sentencing date, and that would give Mr. Rossiter the opportunity to withdraw the plea if that's what he wants to do. And this court could fashion an appropriate sentence, but I'm just not going to go there. But the court will accept the check on behalf of the victim, and we'll get that to the victim as soon as possible. There's, in my estimation, if the check had been paid directly to the victim, perhaps through the prosecutor's office, that might have been the best way to deal with the situation. But that's what we're going to do anyhow. So we'll continue this sentencing in 2 weeks.
2 weeks, that's it.
Okay. What's that date, Ms. Stocking?
So that will be on, today is the 21st, so it's going to be August 4th.
Okay, August 4th. And that'll be for the purpose of this court imposing sentence. Now, I'm sure everything is going to go just as Mr. Richards has indicated, and we're not going to have any problems here, but the check is in the mail with this particular defendant is just not going to work with this court.
Should he make the check payable to the court, or should he make the check payable to the victim? That's what my only question.
The check should be made payable directly to the victim, and we'll just be the handler of that check. And until, in fact, shouldn't even be a check, it should be a money order.
Okay.
Yeah, let's make it a money order. Okay, so, and the court will release that money directly to the victim. All he's got to do is come down to the courthouse and we'll get it to him. And that can all take place prior to sentencing. All right, so anything else for you, Ms. Claxton or Mr. Rossiter?
Your Honor, I guess just procedurally today, will that order be in the system immediately if Mr. Richards comes right away, or should he come to the court this afternoon, or?
Right away.
He should come to the court right away, and Ms. Stocking is here. She's the court administrator, so she knows what the deal is, and she'll get that information to the folks in Antrim right away. In fact, let's deliver it to the Antrim courthouse since the victim is in Antrim. So, okay. All right. So we are all set for today. Safe driving, Mr. Richards. And,
Thank you.
Okay. Is there anything else for you, Mr. Rossiter?
No, Your Honor. Thank you.
All right. Then we're all set. Feel free to sign off at this time, Mr. Richards. Okay, let's go on to People versus Rian Gee. Now, this is a set for a plea this morning, file 213027ST. It was set for 8:50. It's now 9:30 a.m. almost. And Mr. Roster, I believe Ms. Gee is in pro per. Have you had any contact with her?
I have not, but I do believe, Your Honor, that Mr. Hickman may represent her.
Oh,
I think at some point he was involved. I don't know if it was the beginning or the end.
well, let me check on it.
I don't believe so.
You don't see it?
Mm-mm.
Oh, there is an attorney folder here.
There was a pretrial at one
Oh,
point that was sent to Mr. Hickman.
Yeah, it does say Hickman. Now, that seems unusual. It's an operate license suspended, but it is second offense, and there's a no insurance as well. So, yeah, on February 9th, it shows Jessica Allman appointed Ross Hickman. Well, yeah. So, that's unusual.
Well, there's no code in the system that would have notified Mr. Hickman of this.
Ah, okay.
So,
So this, it makes sense that she's not here. What we're going to do is reset it for a plea, make sure that Mr. Hickman is aware of the plea. And thanks for pointing that out, Mr. Rossiter.
Okay.
Okay, so we'll take that off for today and go on to, let's see, Mr. Connolly, are you ready on one of your files?
Yes, Your Honor, I'm ready for the sentencing on Mr. Tillman.
Okay, so let's go ahead to that then. All right, and let's see, is Mr. Tillman present? Mr. Tillman?
That he just joined.
Okay, I see his name on the screen,
Oh, there.
but he's on two different screens. Okay. Okay, can you hear me all right, Mr. Tillman?
I can, Your Honor.
Good. All right, so this is People versus Joshua Colton Tillman, file 213115. And Mr. Roster is here for the people, Mr. Connolly for defendant. This is the date for sentencing on the defendant's conviction of impaired driving. And Mr. Connolly, have you had an opportunity to review the pre-sentence report with your client, and is it accurate and complete?
Yes, Your Honor, we have had an opportunity to review the pre-sentence report. It is accurate and complete. No additions, changes, or corrections.
All right, and let's see, Mr. Roster, any problems with the report itself?
No, Your Honor.
Okay, so Mr. Connolly, what would you like to say on behalf of your client?
Well, Your Honor, first of all, Mr. Tillman doesn't have a lengthy criminal record. He had one wildlife violation from back in 2012. But then after that, it looks like he was in the military between 2013 and 2019, where he received an honorable discharge. He is employed, gainfully employed, Your Honor. I note that he works or is working as a bartender. So I would ask that one of the considerations be made as far as probation terms, Your Honor, that he be allowed to possess alcohol for work purposes only. Other than that, Your Honor, I think, this is just a particularly bad day for Mr. Tillman. I think he didn't realize how much he'd consumed and made the poor choice to get behind the wheel, as we see many times, Your Honor. Thankfully, nobody was injured, including Mr. Tillman. I think this is a good lesson for him, and perhaps a good lesson that parlay into employment. Obviously, as a bartender, having experienced this firsthand, perhaps he can advise others, hey, get a cab, take an Uber. You're not driving out of here. You've had too much to drive based on his personal experience now. So that said, Your Honor, I don't think we'll have any issues with Mr. Tillman on probation, and I would ask that you consider following the recommendations.
All right, thank you, Mr. Connolly. Mr. Tillman, is there anything you'd like to add before I sentence you?
No, Your Honor.
All right, Mr. Roster, anything for the people?
No, Your Honor, this seems pretty straightforward.
All right, then. So this is sentencing on defendant's conviction of impaired driving. The facts are that the defendant had too much to drink at a friend's house. He was driving home and apparently tried to reach for a bottle of water in the back seat and drove onto the shoulder of the road, which caught a police officer's attention. The defendant had a data master test with results of a 0.15. He was arrested and released from the jail the same night. The substance use assessment did not find a substance use disorder, but there were some concerns due to addiction on both sides of the defendant's family. And also the high blood alcohol concentration in this case, not technically under the law high, but a 0.15 is nearly double the legal limit. Those are concerns. And so the recommendation is for continued abstinence and monitoring by the court and attendance at some sort of educational program. They're recommending the Highway Safety Education and Victim Impact Panel. To the defendant's credit, he's 29 years old. He has one prior conviction. Now it's 9 years old, and it is not related in any way to what happened here, a Wild Conservation Act violation. And the defendant is employed full-time and working as a bartender and is an honorably discharged Army veteran. So otherwise, apart from this incident, the defendant seems to be a upstanding citizen, and so I think the recommendations are appropriate and consistent with the rehabilitative recommendations of the assessment. So I am going to place the defendant on a probation. It's going to be longer than the 6 months that's recommended, and that's because, again, this is nearly double the legal limit on the data master test. It's going to be 1 year of probation. The defendant will have the opportunity to seek review of that at the 6 month mark. if he's completed all of the conditions of probation and we're still monitoring and there haven't been any issues, I would consider releasing the defendant from supervision at that time. The fine is going to be $200, cost $400, crime victim $75, judicial system fee is $50, and you'll need to repay the cost of your court-appointed attorney. That's $250. There's also a $100 arresting agency fee. During the term of the probation, you're not to consume or be in possession of alcohol, marijuana, or other mood or mind-altering substances, no non-prescribed medications, and no let's see, and you're to verify any prescription medications with your probation officer within 48 hours so they're aware of what to expect if there were any tests for drugs. You're not to enter bars or casinos. I'm not going to extend that to restaurants that incidentally serve alcohol by the glass, but bars and casinos are off limits except for work purposes. You're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone. Be respectful of court employees and care providers. You're to complete the alcohol highway safety class and victim impact panel. There will be random alcohol testing 4 times per month. And the probation office may adjust the testing requirements accordingly. I would like to get a discretionary test today, and so long as that's negative for drugs, then there will be discretionary testing only for drugs. There is also discretionary testing for alcohol. The jail credit is 1 day, and other than that, you need to notify your probation officer of any contacts with law enforcement. There's a number on the pre-sentence report for you to call after today's hearing, sometime between 1 and 4 p.m. And they'll go over the conditions of probation in more detail with you, answer any questions that you have, including the benchmark test that you're going to take today. And is there anything else for you, Mr. Connolly or Mr. Rossiter?
No, Your Honor. Thank you.
All right, we're all set for today. Good luck, Mr. Tillman. Feel free to sign off at this time and make sure you call our probation office between 1 and 4 p.m., okay?
Thank you, Your Honor.
Yep. All right, is Abigail Christie present? Abigail Christie? How about Andrew Godfrey? All right, well, let's go on then to People versus Robert Bruce. And that is file 213055SD. Mr. Bruce is here with his attorney, Mr. Vlachos, and Mr. Roster is here for the people. This is the date set for a plea. And Mr. Vlachos, is that what your client still wishes to do?
It is, Your Honor.
And is there a plea offer in this case?
There is. Judge Mr. Cruz is going to be tendering a plea of guilty to the amended charge of operating while impaired second offense.
All right. And just, I've been able to hear what you've said so far, Mr. Vlachos, but you might want to lean into your microphone a little bit more.
All right, thank you.
Because it is difficult to hear. Yeah, thank you. All right. So, Mr. Roster, is that a correct statement of the plea agreement?
Sure, I think, because I was having a hard time hearing, but I believe he said he would be pleading to an impaired second.
That's what I heard. Is that correct?
Okay. Yep.
All right. So most importantly, Mr. Bruce, is that your understanding of the plea agreement, you're going to plead guilty to a reduced charge of operating while visibly impaired as a second offense.
Yes, Your Honor.
Okay, and the original charge would be dismissed. Has anything else been promised to you, or have you been threatened, coerced, or forced in any way to get you to plead guilty?
No, Your Honor.
Has Mr. Vlachos answered all your questions to your satisfaction?
Yes, Your Honor.
And do you understand that by pleading guilty, you will have a conviction for operating while visibly impaired and that second offense, and that carries a maximum penalty of up to 1 year in jail?
Yes, Your Honor.
All right. Hang on just a second. All right, I need to go over your trial rights with you and make sure that you understand all those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes, Your Honor.
You also have the right to have witnesses against you appear at a trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if necessary. Do you understand those rights?
Yes, Your Honor.
Yes. In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes, Your Honor.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial, and any appeal of your conviction or sentence would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear an appeal of your case. Do you understand that?
Yes, Your Honor.
Okay. So knowing all those rights, then, is it your desire to waive them all in order to plead guilty to the reduced charge?
Yes, Your Honor.
Right. At this point, I need to ask some questions of you to establish there was, in fact, a crime committed, the crime you're pleading to. So is it true that on January 29th, you were driving your car on North Intermediate Lake Road, a highway in Central Lake Township in Antrim County?
Yes, Your Honor.
And is it also true that at the time you were under the influence of THC or a combination of alcohol and THC?
Yes, Your Honor.
Okay. And which was it? Was it both the alcohol and the THC?
No, Your Honor.
Just THC?
Say that. Sorry, you broke up there. I could not hear you.
Was it just the THC?
THC or what?
Marijuana? Was it just the marijuana, or was it both the marijuana and alcohol?
It was just alcohol. There was THC in my vehicle, but I had not had any that day.
Okay. And do you believe you had enough alcohol that day before driving that your ability to drive a motor vehicle was visibly impaired, meaning that another motorist may have noticed that you were not driving as well as a normal driver, that they would have visibly noticed that you had some impairment?
Yes, Your Honor.
Okay. Was there a test done in this case for the amount of alcohol?
Blood
Yes,
test,
Your
Your Honor, the results were 0.147.
0.147, was that what you said?
Yes, Your Honor.
Okay. All right. So, and you're not disputing that the test result was accurate. Is that correct, sir? Sir, are you disputing that test result of 0.14?
Are you talking to me or Mr. Velakis?
Yes, I'm talking to you now.
Okay, sorry, yes. I don't
Yes,
believe it.
okay. Well, let me ask you this. Based on the amount you had to consume on that one occasion, would you agree that that test result was accurate or at least representative of how much you had to drink?
Yes, Your Honor.
Okay. All right, then to the charge of operating while I guess I better ask you about this other offense here. So is it also true that you were convicted of impaired driving in February 17th of 2015 in the 15th District Court for Washtenaw County?
Yes, Your Honor.
Okay, so that would make this a second offense, correct?
Yes, Your Honor.
Did you have an attorney for that other case?
Yes, Your Honor.
All right. So then how do you plead then to the charge of operating while visibly impaired, second offense?
Guilty.
All right. I will accept your plea. I find it's voluntary, accurate, and understanding. So the next step here would be to get this set for a pre-sentence investigation and a substance use assessment. And we'll set a date for sentencing at least a couple weeks out.
Sentencing dates would be August 4th. Is that far enough out?
Boy, that's cutting
Too
it close
close?
for,
August 18th?
yeah, why don't we go out to the 18th to give Ms. Stanichuk enough time to get that report prepared. So is that going to work for you, Mr. Velachos?
At 9:45.
That's fine, Your Honor. And Mr. Gruz has been screened already, and I believe I've already furnished a copy of probation. If I haven't, I will.
Okay, so the 18th, and that'll be at 9:45 a.m. And Mr. Gruz, oh, you said you do have a assessment already, Mr. Velachos?
Yes, Your Honor. Mr. Fowle did an assessment shortly after this incident occurred.
Okay, good. So if you get that to the probation officer, then we've got that part out of the way. Mr. Gruz, you will need to contact the probation office today between 1 and 4 p.m. I'll give you a number for that. It's 231-922-6899.
Okay.
All right. So anything else for you, Mr. Velachos?
No, Your Honor. Thank you.
Mr. Rossiter, anything else?
No, Your Honor, thank you.
Okay, I think we're all set for today then, so feel free to sign off at this time, Mr. Gruz. I'll see you back for sentencing.
Thank you, sir. Have a great day.
Yep. All right, Mr. Roster, do you have any information about Abigail Christie's? That was scheduled for 9:10 this morning, and haven't seen Ms. Christie.
It looks as though, again, she may be represented by Mr. Hickman. As I see, we had sent a pre-trial statement at one point.
Is this another one? Yeah, is this another one, Ms. Stocking, where maybe he wasn't aware of it? Or?
Well, Mr. Hickman typically doesn't file appearances, which means he then doesn't get noticed.
Is that what's going on here? Yeah, I don't see an appearance. I see an attorney file.
Yep.
That shows the appointment paperwork.
Right,
but,
and then he doesn't file an appearance, so then when we get the notices, he doesn't get the notice.
all right.
And so that's what happened on the other one, is he did not file his appearance in the case.
All right, so you're going to talk to Mr. Jarboe about that?
Yes, I will.
Okay. guess the same as, well, Mr. Godfrey, now that's a operate with no insurance. I wouldn't expect an attorney to have been appointed there. But
I don't see anything in my records, Your Honor, that would indicate an attorney was involved.
okay. Do your records reflect whether you had a pretrial and case and Mr. Godfrey responded appropriately?
Oh, just a minute. It appears as though I misspoke. I have an email that was sent June 22nd, and the email was sent to Mr. Hickman. I'm going to guess at some point.
In what case are we talking about right now?
This is Andrew Godfrey, 3051. And, you know, I guess Ms. Allman was a bit more generous than I am as far as appointing court-appointed counsel, because there is another form here appointing Mr. Hickman in that case, and apparently he did not file an appearance again. So
that's the case.
3 cases one day. Okay, so we'll go ahead and adjourn those out to the next, August 3rd, you said?
August 4th.
August 4th?
Yes.
Okay, so those will be adjourned out to August 4th. And we'll make sure Mr. Hickman is aware of those. Is Ms. Claxton present?
Yes, Your Honor.
All right, good morning. And let's see, is Mr. Lowry going to be here for this competency hearing?
Your Honor, I'm not sure. Mr. Lowry represents himself in this case. I'm standby counsel. I have not talked to Mr. Lowry since before the last court hearing.
Okay. Let's see. And Mr. Roster, do you know, is Mr. Lowry on bond?
Is.
All right, I don't see anyone in the meeting that would be Mr. Lowry. So I guess we'll give him a few more minutes to show up. That case was noticed for 9:45. And the defendant is not present. All right. Well, I have little hope that Mr. Lowry is going to show up this morning. He was noticed. Is that correct, Ms.
Yes. Mhm.
Stocking? Okay. So I'm going to go ahead and call the case. This is file 202839FY3, Charles, People versus Charles Daniel Lowry II. Case was noticed for 9:45 this morning. It's now 9:58 a.m. I would note, for purposes of not showing up this morning, that the competency and criminal responsibility reports both came back. And for what they're worth, again, with regard to bond in this case, Mr. Lowry was found competent, and the examiner did not find evidence of that his mental illness affected his ability to understand the wrongfulness of his conduct. So let's see, Mr. Rossiter, how do you wish to proceed at this point?
I don't know if the court's issuing bench warrants for failure to appear, or if they have to have another bite at the apple. But this has been, let's see.
Can you tell if it's ever been adjourned?
The complaint was filed back in August of 2020. Looks like he failed to appear for his competency exam back in June 25th as well, or the competency hearing rather.
It kind of looks like the only time he's ever appeared in court was when he was in custody.
You said he failed to appear for what hearing, Mr. Rossiter?
Looks like it was a competency hearing.
And what date was that?
June 25th.
That order was
June
signed
20.
on June 25th.
Yes.
All right.
He's
Well,
in the area. I see him walking his dog. I see him in the grocery store. He's around.
Okay. Well, for whatever reason, he's didn't appear today or on June 25th. Ms. Claxton, any argument why I shouldn't cancel the defendant's bond at this time?
Your Honor, just for further information on that first failure to appear, that competency exam was set the day before, so he wouldn't have received a written notice for that hearing. I'm not sure what happened for this hearing today, so I'd leave it to the court.
Okay, well, I'm going to cancel bond at this time, issue a bench warrant, and figure out what's going on. I also noted that the defendant has failed to appear a number of times for drug testing, most recently on June 12th. So that's another reason why I'm going to cancel his bond. Okay, well, thank you, Ms. Claxton, and we're all set then on that case. All right, let's go on to.
Do you have a bond amount you'd like me to write on this dispo?
No, bond is just canceled.
Oh, got it. Thank you.
Yep.
Got it.
All right, so let's go on to file 213093SM, People versus Christopher Pichet. And let's see, Mr. Fisher is here on behalf of Mr. Pichet, who's also present. And let's see, Mr. Roster is here for the people. This is the date set for a show cause hearing. Give me just a minute to pull up my file.
Your Honor, Joseph Fisher on behalf of Mr. Pichet. The reason for the show cause is because no pretrial statement was ever signed, and the court should have one in the file now that was signed by myself and Mr. Pichet on July the 7th, by Mr. Rossiter back in June. I can't tell for sure if it's the 21st. Anyway, if the court please, maybe could dismiss the show cause and proceed to take a guilty plea from Mr. Pichet consistent with the pretrial statement.
All right, and that is a plea to added count 3, attempted disturbing the peace. Counts 1 and 2 will be dismissed. Is that correct?
Yes, Your Honor, that is correct.
All right, Mr. Roster, is that in fact the offer?
Yes.
All right, so most importantly, Mr. Pichet, is that your understanding of the plea offer as well? You'd be pleading guilty to an added count of attempted disturbing the peace with a maximum penalty of 45 days in jail, and the original assault and battery charges would be dismissed.
Sir, yes, sir.
Okay. Has Mr. Fisher answered all your questions to your satisfaction?
Sir, yes, sir.
Do you understand that by pleading guilty, you will have a conviction for attempted disturbing the peace, and that carries a maximum penalty of up to 45 days in jail?
Sir, yes, sir.
Let's see. Has anyone promised you anything else to get you to plead guilty, or if you've been threatened, forced, or coerced in any way to get you to plead guilty?
No, sir.
I need to go over your trial rights with you and make sure you understand all of those before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor, and you have the right to a jury trial to make that determination. Do you understand all of those rights?
Sir, yes, sir.
You also have the right to have the witnesses against you appear at a trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Sir, yes, sir.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence cannot be used against you in any way. Do you understand that right?
Sir, yes, sir.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial, and any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear any appeal of your conviction or sentence. You understand that right?
Sir, yes, sir.
All right, so then to the added count of attempted disturbing the peace, how do you, oh, I'm sorry, I guess I better establish some facts here. So do you agree to waive all of those rights then in order to plead guilty to the lesser offense of attempted disturbing the peace?
Sir, yes, sir.
All right, so I do need to ask some questions to establish there was at least a disturbing the peace. So is it true that on April 10th of this year, you were at a location in Kearney Township in Antrim County, and you were with a Mary Jo Reimersma? Was that a yes?
Yes.
Okay. And what did you do to disturb the peace?
Well, I was quite
I'll tell you what.
irritated. I was irritated with the fact that the tenants below me continued to smoke after I asked them numerous times to please stop. And they disrespected me and continued to smoke. And that's what provoked my disturbing the peace.
Okay, Mr. Fisher, why don't I have you ask some questions to establish the basis for disturbing the peace? I don't know if it's a plea to the assault with the understanding I'd be taking the plea to the lesser, or if it's actual disturbing the peace.
I think it's more the latter, Your Honor. So let me go ahead with some questions for Mr. Pichet to establish a factual basis. Christopher, you were irritated because these folks were smoking. Is that correct?
Yes, sir.
All right. So in response to that, you confronted them in some way, and they ran into a house or into the condo where that they were renting.
Yes, sir.
And then you proceeded to pound on the door and raise all kinds of havoc. Is that correct?
Yes, sir.
And if I'd been standing nearby observing all of this, do you believe that my peace would have been disturbed?
Yes, sir.
Thank you. Your Honor, I have nothing further.
All right, Mr. Roster, are you satisfied there's a sufficient factual basis for the plea?
Yes, Your Honor.
All right, then to the added count of attempted disturbing the peace, how do you plead, Mr. Pichet?
Guilty, sir.
All right. Well, it's obvious that your plea is understanding, voluntary, and accurate. I will accept your plea. I will need to set this for sentencing down the road. Let's make it August 3rd. Rather than a pre-sentence. Oh, what's that?
It's the 4th.
The 4th. I'm sorry. August 4th is our next day. Is that going to work for you, Mr. Fisher?
What time will it be by Zoom, and what time of the day, please?
Yeah, it would be by Zoom.
Do they schedule them every 10 minutes apart? 9:45 was
usually 15 minutes.
So 10 o'clock, please.
10 o'clock.
Yes, Your Honor, that'll work.
All right. And rather than well, let's go ahead and get a pre-sentence report. But I do need to give the victims 10 days to get notice of the sentencing if they care to appear at the sentencing hearing. So what I need you to do, sir, is to contact our probation office sometime between 1 and 4 p.m. today. And if you could write this number down, I'll give you that number. It's 231-922-6899. They're going to prepare a description of the incident, and they want to get your side of it. And they may contact the victims as well, or look at the police report to determine what information is in there and anything else relevant to my decision. So we're all set for today, unless there's anything else.
One more thing, if I might, Your Honor. Would you address the daily testing, perhaps reduce that to random? I think Mr. Pichet's been taking daily tests since April, and with no HOTS, and ask that you consider that, please.
And did this case involve alcohol?
It did.
Was there a test result?
No, I don't think any test was taken at the time, but Mr. Pichet would indicate that he was intoxicated at the time.
Okay. And Mr. Rossler, do you have any concerns about lowering the testing requirements at this time?
Oh, no, Your Honor.
Okay, let me just check and make sure that I don't see any violations. So let's go ahead and read. Let's see, April is May, June, July. 3 months of no positive. So I'm going to reduce the testing requirements to 4 times a month. And I think we're all set then. Is there anything else, Mr. Fisher?
No, thank you, Your Honor.
All right, and Mr. Rosser?
No, Your Honor, thank you.
Okay, we're all set then. Make sure you call that number today, again, between 1 and 4 p.m., Mr. Pichet, and we're all set. Feel free to sign off at this time.
Yes,
Thank
sir.
you.
Thank you.
Mhm. All right, do we have a representative of Forefront Credit Union here? How about Tamari Miller? Ms. Stocking, do you know anything about the Forefront Credit Union case?
I was just in the ROA of that, and it doesn't look like they asked for it to be adjourned in May because there was no service, but then it was scheduled for today, so I don't know whether there was actual service on it or not.
Okay, again, any representative here from Forefront Credit Union or Tamari Miller? All right, it doesn't appear so. So I guess at this point, I'm just going to dismiss the discovery request. I don't see any reason to set that for another hearing at this point. If Forefront is still pursuing this, then I'm sure we'll get another subpoena.
Correct.
Okay, let's go on to People versus Kayla Adams. Is Kayla Adams present?
Yes.
Okay, how about Mr. Connolly? There he is.
Good morning, Your Honor.
Your Honor,
Good morning. Yeah, Mr. Roster.
to try to keep things moving along, it's my understanding Miss Adams is going to enter a plea. While she's doing that, could I be put in a breakout room with Mr. Hickman regarding the final conferences?
Oh, with Mr. Hickman, you said?
Yes, there are 2 final conferences that are scheduled.
Okay, and we'll go ahead and take the plea on Miss Adams' case according to the pretrial statement. So let's see, Mr. Roster and Mr. Hickman, and there you go. All right. Mr. Connolly, is that correct? Your client wishes to plead guilty today in accordance with the pretrial offer.
Yes, Your Honor, that is correct.
What is the offer?
Your Honor, the offer is to plead guilty to count 1, which is the possession of mushrooms, and to dismiss count 2, which is the operating without insurance or security.
All right. Is that a correct statement of the plea agreement as you understand it, Ms. Adams?
Yes. Yes, it is.
All right. Has anything else been offered to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No.
Has Mr. Connolly answered all your questions to your satisfaction?
Yeah.
You understand that by pleading guilty, you will have a conviction for possession of a controlled substance, that being psilocybin, and that carries a maximum penalty of up to 1 year in jail.
Yeah.
All right. Let's see. I need to, if anyone else is on the call, if you could mute yourself at this time other than Ms. Adams and Mr. Connolly, I'd appreciate that. I'm getting some background noise. Oh, I just muted you, Mr. Marshall. So, but thank you. All right. So, Miss Adams, I need to go over your trial rights with you. Make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt. And you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes.
You also have the right to have witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that right?
Yes.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial, and any appeal would be up to the appeals court whether to even hear your case if you were to appeal your sentence or conviction. Do you understand that?
Yes.
All right, then. I need to ask some questions at this point to establish there was, in fact, crime committed. And so is it true that on April 25th, you were at a location in Mansalona Village and Antrim County, and you were in possession of psilocybin, also known as psychedelic mushrooms?
Yes.
Okay, and let's see. Did the police contact you? I don't know, were you pulled over or something like that? Is that how they found that?
No, I left my house because me and my boyfriend were in an argument, and the cops were called from the next door neighbors that we lived by that we were in an argument. So the cops had to pull me over to see if I was all right.
Okay, and because of that stop, they eventually discovered the controlled substance then?
Yes.
All right, then to the charge of possession of a controlled substance, Schedule 5 or LSD, in this case psilocybin. How do you plead?
Guilty.
All right, I will accept your plea, find it's voluntary, accurate, and understanding. I am going to set this for a substance use assessment and a pre-sentence investigation report. I'm going to need you to contact our probation office between 1 and 4 p.m. today. Do you have a pen handy?
Yes, I do.
Okay, so the phone number is 231-922-6899.
Okay.
Again, call them between 1 and 4 p.m. and they'll help you out as far as any questions that you might have at this point, and they'll set up an interview.
Okay.
Let's see. Anything else, Ms. Stocky?
Do you need a sentencing date?
Oh, yeah. Let's set that up. So let's go with the August 4th date again.
10/15?
Yeah. All right. So you'll be back here on August 4th at 10:15 a.m. And is there anything else for you today, Mr. Connolly?
No, Your Honor. Thank you.
All right. We're all set. Ms. Adams, feel free to sign off at this time.
Okay, thank you.
All right, I see Mr. Roster and Mr. Hickman are back. So let's see. Is Ralph Marshall present?
He is.
Oh, that's the gentleman I think I put on mute. So if you could unmute yourself at this time, Mr. Marshall.
Okay, you guys got me?
Yes, I can hear you just fine. So this is file 202992ST, People versus Marshall, and Mr. Hickman is here on behalf of Mr. Marshall, Mr. Roster for the People. And this is the date for a final conference. Is there any plea agreement or is this going to go to trial, Mr. Hickman?
No, Your Honor, this matter will be resolved in by way of plea. Mr. Marshall will be pleading guilty to no insurance, and the other counts will be dismissed.
All right. Is that a correct statement of the plea agreement, Mr. Rossiter?
It is, Your Honor.
All right. And most importantly, Mr. Marshall, is that also your understanding of the plea agreement? You're going to plead guilty to count one, the operate without insurance, and the other two counts will be dismissed.
Yes, sir.
All right. So I know you just heard these, but I'm going to need to go through your trial rights with you. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand those rights?
Yes, sir. Yes.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses. And the court would order those witnesses to appear if need be. Do you understand those rights?
Yes, sir.
In addition, you have the right to remain silent, and that silence could not be used against you in any way, or to testify if you choose to. Do you understand those rights?
Yes, sir.
And finally, when you plead guilty, you give up the right to appeal you'd have if you went to trial. Any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether you're an appeal of your conviction and sentence. Do you understand that?
Yes, sir.
So do you wish to waive those rights in order to plead guilty to the reduced charges?
Yes, sir. Yep.
All right. Is it true that you were driving your Ford pickup on November 25th of 2020 at a location, let's see, on Beach Street in Star Township in Antrim County?
Yes, sir.
And is it also true that at the time you didn't have any insurance on that vehicle?
Yes, sir.
All right. So then to the charge of operating without insurance, how do you plead?
Guilty.
All right. I'll accept your plea. I find it's voluntary, accurate, and understanding. The other two counts will be dismissed. Is there any reason I shouldn't go directly to sentencing in this case?
No, Your Honor, we would ask you to.
Mr. Rossiter, you agree?
I agree.
All right. So, Mr. Hickman, what would you like to say on behalf of your client?
Your Honor, we would ask that the court impose a sentence of fines and costs and give Mr. Marshall some time to pay the fines and costs. I think I think he understands that he can't drive without insurance and that this won't happen again. Obviously, he has a long criminal history, but this is minor in comparison, and we'd ask the court to just impose fines and costs.
All right, Mr. Roster, what's your position?
Marshall needs to do three things: get insurance, register his truck, and renew his driver's license.
I don't have the truck no more, so okay.
Well, then do 2 out of 3, but just don't repeat this.
Yes, sir.
Okay, so Mr. Marshall, is there anything else you'd like to say before I sentence you?
Yeah, I just started working again, and I work at the Boyne Falls Mountainside Grill, so I don't have no problem paying payments.
Okay, well, good. So this is sentencing on defendant's conviction of operating without insurance. It appears the defendant does have a lengthy history, and this is obviously not the first involving traffic infractions. In this case, he was also charged with unregistered vehicle and no license, and those have been dismissed. But every time you get caught driving, you know, it ends up costing you more money and making it even harder to get your license back. So hopefully you've got a ride with someone to get you to your work. Glad to hear that that's working out well. So I'm going to impose standard fines and costs. That's going to be a $200 fine, $100 cost, $75 crime victims fund, $50 judicial system fund fee, and that's $425 total. You'll also need to repay the cost of your court-appointed attorney, Mr. Hickman. So I guess that makes it $675. Now, this is the thing. I can't set up a payment plan, and you're not going to be able to do that. We now have well, you may be able to do that through our collections agency. What you should know is if you don't pay within 56 days or set up a payment plan with them, they tack on a 20% fee. So get on that, get with the collections agency and let them know what you think you can afford to pay and how you're going to get it paid off, okay?
Yeah, I was thinking like 125, 150 every paycheck every week.
Well, that would certainly take care of it, and I'm guessing they would go along with that. So, all right. Well, we're all set for today then, and good luck with that, sir, and feel free to sign off at this time. What's that?
Who do I get in contact with this? Who do I contact about this?
Okay, you can call the clerk's office at 231-533-6441.
All right, thank you.
All right, thank you.
Yes, sir. I can go off now?
Yep, you're free to leave the meeting if you like.
All right, thank you. Bye-bye.
So let's go, yep, let's go on to final conference in file 202983ST, People versus Brian Frazier. And Mr. Hickman is here on behalf of Mr. Frazier. Let's see, is Mr. Frazier present?
I don't believe so.
Okay, so let's see. Do you know why he's not present today?
No, Your Honor. I do not.
All right. Has he been cooperative in the case? He's talked to you in the past?
Yes. I assumed he'd be here.
All right. Mr. Rossiter, what's your position?
If he had, I'm just looking, I don't know if he's failed to appear before or not.
I don't think so.
This is also another case where Mr. Hickman has not filed an appearance.
Ah,
Well,
okay.
there's not an appearance
So-
on this?
Nope.
Mr.
Wow.
Hickman,
There will be.
okay. So let's go ahead and
Records say
reset
I
this
have.
then for the August 4th date. You want to set that up?
Actually, I apologize, Mr. Hickman. You have filed an appearance in this case. My apologies. I was on the wrong
okay.
dispo here.
All right. Well, nevertheless, let's give him one more opportunity. Has this been adjourned before from a
I'm
final?
taking a quick peek. I was in the
Okay.
wrong case when so let me look. He failed to appear for, he failed to appear for his arraignment. It was reset again. He did appear the second time. It looks like he only had that one fail to appear on the first arraignment.
Okay, so let's go ahead and reset for the 4th then, and hopefully you can reach out and make sure he's aware, besides our notice, that he needs to be here the next time, okay?
Yes, thank you, Your Honor.
All right. Let's see. We're up to the formal hearing at this time, and that is, I'm going to take a break here, but before we do that, I wanted to just see where we're at with the Ecker case. And let's see. Who's representing Jordan Township?
Myself, William Derman.
Okay, Mr. Derman. And let's see, we have the Eckers present, Patrick and Elizabeth. And Mr. Rossiter, you're here. Well, no, it's Mr. Derman that's going to be representing the township. So
that's correct.
Has there been any resolution of the case?
There has not, Your Honor, even after the 4 notices.
Okay, so you're anticipating a hearing this morning then?
I am, and depending on what the Eckerts say. There has been no contact with Dennis Kenny, the enforcement officer, and he's left his business card and he's forwarded the notices 3 times on this. So they've made no effort to contact either him or the township.
All right, and you're prepared to go forward with the hearing this morning, is that correct?
That is correct.
Okay, so Mr. and Mrs. Ecker, are you prepared to go forward with the hearing this morning? You're muted right now. Can I get you to unmute? Uh-oh, I still can't hear you. And you're unmuted. So can you see if maybe your volume is not turned on all the way?
It says it's on.
No, it's not.
That one.
Oh, I can hear you now.
There we go.
Now it's on.
Okay. Have you been able to hear everything up to this point at least?
Yes.
Yes.
Okay. All right. And so we're going to have a hearing here unless you've had any change of heart about pleading to the violation.
No, we've been working on the property.
And 2, we ain't got that many notices. And yes, we've had contact.
Okay. Well, it sounds like we need to have a hearing anyway. So I'm going to take about a 10-minute break. We'll get started at 1:45. And the way this is going to work is Mr. Derman will present his witnesses. How many witnesses do you think you'll be calling?
1.
Just the enforcement officer, Mr. Kenny, then. And then you'll have a chance to question Mr. Kenny after he's testified for Jordan Township. And then you'll have an opportunity to testify yourself. All witnesses will be sworn under oath. And you can present any other evidence that you might have, whether it's a document or if you have a witness here. Do you have any other witnesses besides yourselves?
No.
Not at this point.
Okay. All right. So, and then I'll give you a chance to make a brief opening statement before we get started with testimony. And if you want to, you don't have to. And a brief closing statement after we've heard all the evidence. Okay. So I'll be back in about 10 minutes.
Thank you, Your Honor.
Thank you.
I ain't the same guy I talked to. That guy was rude as shit. I do have a witness.
No, unless you can get Mikey here right now.
You guys are still live, like your
I don't have
phone is
my
not
phone.
muted.
How can I get Mikey here?
Everybody can hear what you're saying, so you might want to mute.
Get Mikey here right now. Come, he'll be right here. 'Cause I already talked to him last night about it. Deegan's in the fucking camper and then helped the fuck out. And proved that we had a 20-yard dumpster out there cleaning up.
You guys are live, and everyone can hear what you're saying. You might want to mute your phone so that you're not broadcasting your comments to everybody.
Sorry about that. Thank you.
Oh, yeah. You want to switch then on Saturday, put me on?
You did again.
And for all I know, Carrie might not call in tonight. Like, I don't know. She's going to factor, but in case she does, I plan on going to the path and bringing in some items. And then I really kind of plan on leaving in case I do have to come in tonight. Because I'm already going to be working like over 50 hours this week. So I'm not too concerned about not making my hours.
Speaking of hours, I don't write it down every day, I forget, and paychecks is always not right. I do not understand that thing at all. I'll go to punch out and I'm already punched out, and I hadn't touched it since I punched in the morning, and I tried to look at it the other day and finally figured out how to get on there, and I'm like, hi. Hello. Can I grab the nail stuff, please?
No, I did not complete it.
I'm
gonna get in trouble if I put it all.
I can give it to you in a little bit. I have someone on court right now. So
I've been in trouble through EDS, but not for that. I've been in trouble for.
She went, oh, I know, she hurt herself, she's a big girl. No, I didn't. Why do I feel guilty about this?
I don't know.
I do, I feel horribly guilty that I didn't write a progress note.
when they let you in, let me know. I'll make.
I'm really behind on mine. I gotta get that shit done like
I'm
ASAP.
in court.
So I should be doing today, but if I work that midnight shift tonight, then I'll definitely have them done.
Yeah, you're muted.
Lord,
Done? Is this done?
All right, we're back on the record then in file 0105ON and 0107ON, Jordan Township versus Patrick and Elizabeth Eckert. Mr. Derman, would you like to start out by making a brief opening statement?
Sure. Jordan Township has passed in 2018 a anti-blight ordinance. The property owners, Mr. and Mrs. Eckert, given really 4 notices by the township, 3 by Mr. Kenny, regarding their violation of the ordinance. The Eckerts have not complied, have not contacted Mr. Kenny or the township board regarding this matter, and appears to have made no effort to clean up the situation. The township was forced to proceed with the civil infraction on schedule today. That's all.
All right. Mr. or Mrs. Ecker, would you like to make an opening statement?
Yeah, I personally have not been contacted by anybody. My husband said that he remembers 2 different people talking to him. And he did try to contact somebody who left a card on our door and never received a call back from anybody. He has also gone to Antrim County and where we pay our taxes out and asked them how to go about getting this taken care of. We have also been working on our property.
Okay. All right. So, Mr. Derman, why don't you go ahead and we'll call Mr. Kenny. So, Mr. Kenny, you want to raise your right hand?
I also have
Oh, hang on. Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, sir.
Was that a yes? I'm sorry. Oh, I can't hear you, sir. I guess I should have checked that before we got started.
Sir.
Now I can hear you. Okay. Again, do you swear or affirm that the testimony you're about to give will be the truth?
Yes, sir.
Okay, put your hand down. Go ahead, Mr. Derman.
Okay, will you state your full name and address for the court, please?
Michael? No, not you.
Okay, I'm going to mute, or this is what we're going to do. Okay, Mr. and Mrs. Ecker, if you could stay silent, I won't have to mute you, but if you have some objection you want to raise, then one of you raise your hand so I can see it on your camera there. And we can stop and I can take up that objection. But everything you say I can hear, and it's difficult to hear the testimony, okay? All right, go ahead again, Mr. Derman, if you could restate the question.
Kenny, would you please state your full name and address for the court?
Sir, Dennis Jean Kenny, Road, again 49727.
Your Honor, I am not hearing all. It's garbled.
Well, it was a bit garbled, and I'm not sure what kind of device you're using there, but I could make out most of what you said, and it might be that you need to hold it closer to your mouth, or perhaps hold it still more. So let's give it another try. What's your name?
Dennis Kenny.
That's better, I think, if you hold it still and lean into it like that. Let's try it, Mr. Derman, and see how it goes.
Okay. Are you the ordinance enforcement officer designated for Jordan Township?
Yes, sir.
Does that include the enforcement of Jordan Township anti-blight ordinance?
Yes, sir.
What's your normal procedure if you locate a violation of this ordinance?
Try to contact me.
Okay, that's where for some reason, I'm not hearing you now, Mr. Kenny. Well, I can hear, but it's garbled again. Let's try it again.
Normally, I try to contact the property owner
face to face about what we discussed or what happened today.
Okay, hang on a minute. This is going to be difficult, I think. The other thing, is that your cell phone you're talking into?
No, sir.
No, it's a.
I just bought.
Okay, one of the things that seems to work better is if you simply log into the meeting on your cell phone or use the call-in number. And do you have the notice in front of you that gives you that number?
I can pull it out, sir.
Okay. Ms. Stocking might have it handy
I
too.
do. Did he say he found it?
Oh, he's still looking.
It's 646 876 9923. And then the meeting ID would be 242 305 0413.
Enter your meeting ID followed by pound.
Say that.
Did he ask me to say that?
I think he wants you to say it again.
The meeting ID is 242 305 0413.
Enter your participant ID followed by pound. Otherwise, just press pound to continue. You are in the meeting now.
He's going to need to sign off the other device.
Oh, you're going to have to sign off your other device now that you're connected by the phone.
As far as just muting it or
Oh,
completely
that's
sign out?
perfect right there. Okay, now I can hear just fine and I can see you too, so.
All right.
All right, so why don't you ask the last question again, Mr. Derman?
Kenny, what is your normal procedure after you locate a violation within the township?
I normally try to contact the property owners in person and discuss it with them to see what we can do to become compliant with the ordinance. And I take photos of the non-compliance for future record.
Have occasion to contact records?
Yes, sir.
I'm going to back up a little bit. Did you receive the exhibits that were sent to the court on July 15th, 2021? There's a list of 10.
Yes, sir.
I'm just going to go through those two, so I will answer a lot of the questions. Proposed Exhibit 1 is the Jordan Township Light Ordinance, which was adopted in 2018. Is that still in effect?
Yes, sir.
And does this prohibit the accumulation of junk as defined therein on a property owner's property?
Yes, sir.
And it provides that it cannot be viewed from the roadway. Is that correct?
Yes, sir. The roadway and adjacent property.
And the potential fine and costs are what?
$500 per day.
Plus court costs?
Excuse me, sir. I didn't hear that.
Question, plus court costs?
Oh, plus court costs. Yes, sir.
I've also attached as a proposed exhibit the tax roll for Mr. and Mrs. Eckert. Is that a fair and accurate representation of their tax rolls?
Yes, sir.
And the attached tax map. Is that a fair and
Yes, sir.
accurate representation? I've also attached as proposed exhibit 4 a copy of their deed, which they purchased the property in March 6, 2018.
Yes, sir.
Is that a fair and accurate representation? Okay. I also have attached a violation notice dated, December 2nd, 2019, signed by Steve Huffman. Who was Steve Huffman?
Steve Hobman was my predecessor, the previous blight or the previous ordinance officer.
Okay, and did that indicated that there was violation consisted of old tires and trucks?
Yes, sir.
On went to notice violation on April 7th. This was signed by you?
Yes, sir.
And what did you do on April 7th? Indicated.
I stopped, talked to Mr. Ecker, tried to explain the ordinance to him. I brought him a copy with my business card, and I was pretty much told that I was the third person to talk to him, and when he got around to cleaning it up, he would clean it up.
That's not true.
Okay, hang on, Mr. Ecker. You will get a chance to testify, as will Ms. Ecker, and but it is not appropriate to interrupt, okay?
Sorry.
Unless there's an objection to the testimony for a legal reason, okay?
Okay.
All right. And just because you have a disagreement as to what the facts are, that's not a legal reason, okay? So go ahead, Mr. Derman.
Did you also advise him and encourage him to contact the township board regarding this violation?
Yes, sir. I do with every notice, and I did in person.
And you indicated that the violation was multiple unregistered vehicles, junk, and tires on the property. Is that correct?
Yes, sir.
Did you ever, after sending the notice, did you ever receive any contact from Mr. and Mrs. Eckert?
No, sir.
Thereafter, Exhibit 7 was a final notice signed by you on May 23rd. Is that correct?
Yes, sir.
And again, you encouraged them to contact the township or yourself to discuss the violation, correct?
Yes, sir. Yes,
And
sir.
you received no comments from them or no
No,
contacts?
sir. No, sir.
Then again, on June 15th, the Exhibit 8 was the final notice of violation, ticketing notice of violation. You indicated thereon that you had zero or significant compliance had been noted on the property, even after visiting the property, again, drive by the property. Is that true?
Yes, sir.
And at that date, you issued the civil infractions for both Mr. and Mrs. Eckert. Is that correct?
Yes, sir. Yes, sir.
File them with the court.
Yep.
Occasion to take photos recently of the property from the roadway.
Yes, sir. Yes, sir.
Okay, I'm going to stop you right there, Mr. Derman. I've tried to tolerate this feedback, but it's starting to really get annoying. So I think what you need to do is to sign off the first device that you were on, but stay connected on your phone. I probably won't be able to see you at this point.
Is that better, sir?
Let's see, Mr. Derman, can you ask a question and see if I get the same feedback or not?
Did you have occasion to take photos of the recently take photos of the property from the road?
Yes, sir.
Thank you.
I proceed, Your Honor.
Yes, go ahead. I just had to mute the jail there.
The you had occasion on proposed exhibit 10 is 5 photos. Can you discuss those photos, please? Let's start with the tires.
There's one big pile of tires out in the immediate open area of the field in front of their property. It's kind of hard to see and be able to, their house is quite a distance off the road. So it's kind of hard to see, but right in the edge of the wood line, there's other piles of tires that in the summertime with all the foliage and everything on the trees and the grass and everything, it's kind of hard to get a picture that close, but you can see them.
Hey, Is there vehicles on the property?
Yes, sir. You can see the pictures of the truck and on jack stands, and there's a shed there, some snowmobiles. I can't remember exactly. I'd have to pull up the pictures to see everything, but I think there's one or two cars and another pickup.
And your opinion as zoning enforcement officer is that these are in violation of the Jordan Township ordinance?
Yes, sir.
Have you had any contact with Mr. and Mrs. Eckert after the court hearing date was scheduled?
No, sir.
That's all I have for this for the testimony, Your Honor.
I have a question. Were the photos, Mr. Kenny, were they taken from the roadway?
Yes, sir, because I normally try to work with the property owner, but my first engagement with Mr. Ecker was not very pleasant. So after that, all I do is drive by the property, take pictures from the road, and then send a letter.
Okay.
If
All
the
right.
property owner is not willing to work with me.
Okay. Thank you. Mr. Derman, are you moving to admit those exhibits?
Yes, I am, Your Honor.
Okay, so I will admit those exhibits unless there's some objection. All right, so at this point, Mr. and Mrs. Ecker, you can ask, I'll have one of you, whichever you decide, ask questions of Mr. Kenny, okay?
Okay.
If you have any.
He never told me anything. He never got any information, and he took pictures.
I don't believe that we have any direct questions for him. Sorry.
Okay. All right. So Mr. Kenny is excused then. And Mr. Derman, do you have any other evidence or witnesses you want to present?
Do not, Your Honor.
Okay. Before we go to the Ecker's testimony, I want to see where we stand with the rest of this morning's docket. We've got a, let's see, is Rain Schaefer here on the probation violation?
Yes. I'm here.
Okay. All right.
And Your Honor, I would need to break out with Schaefer because her phone's going right to voicemail.
Okay, well, I can go ahead and set that up, but hang on just a minute here.
Yes, Your Honor.
Do we have any quick resolution of any of these preliminary examinations that were scheduled for 11?
Mr. Gibson, Your Honor.
Mr. Rossiter, Mr. Dixon.
Gibson.
Gibson.
Sorry.
Okay, what's going on with Gibson?
That's going to be a request for competency and responsibility, Your Honor.
Oh, I thought that was going to be Wiltsey, but
no.
Is that also?
Wiltsey is going to be held. Gibson is the competency and responsibility.
Okay. All right. So we're anticipating a hearing on Wiltsey, and Gibson is referred for competency. I assume you don't have any objections to that, Mr. Rossiter?
No, I have no information one way or the other.
Okay. So you want both competency and criminal responsibility, Mr. Connolly?
Yes, Your Honor, please.
Okay, so Mr. Roster, you'll prepare an appropriate order on that?
Yes, I get it. I would, before I do that, I briefly spoke to Mr. Connolly this morning, and I don't know, was there a request is there a Charlevoix matter where there was a request for?
Mr. Gibson, can you unmute? Mr. Gibson, can you unmute your...
Mr. Gibson, could you unmute yourself?
I think
I'm not there. There you go. I think you're unmuted now.
Okay.
So,
Here you
Mr. Gibson, in your Charlevoix County case with Attorney Doak, have you already requested competency and responsibility?
No, that arraignment was just yesterday, sir, and it's not set for preliminary until I believe the 26th or 28th of August. But I'm going to talk with her today or try to, and that's what I'll be requesting in that county as well.
All right, I think I got that.
Maybe you could translate for me.
It sounds like he's got a prelim coming up in Charlevoix County, and his intention in that matter is to request competency and responsibility. So I think I misunderstood him this morning. I thought he'd already done that, but it sounds like he will be doing that in Charlevoix.
All right. So anyhow, I think we're all set for today, unless there's anything else for you, Mr. Connolly or Mr. Rossiter.
I guess just briefly, Your Honor, and I'm not trying. We have been inundated with, it seems, requests for competency and responsibility, and I'm just wondering what the basis is for the request from Mr. Gibson.
Because it is my right.
The request is based on Mr. Gibson's past mental health and current medications he takes for that. So that's the basis.
All right. Well, your concern is noted, but I don't believe this court should get involved where the defense counsel has spoken with the defendant and met with the defendant and feels that a competency hearing is important. So, and apparently that's the opinion of the attorney in Charlevoix County as well. So anyhow, if you could prepare an order, Mr. Roster, I'd appreciate that. And we're all set for today, Mr. Gibson. So feel free to sign off at this time, okay? All right, thank you. Okay, Mr. Gardner, you're here on behalf of Munson Medical Center. Is Mary Holm present? Mary Holm? Now's the time to speak up if you're here. I'm going to check my participant list to see if maybe she's just not able to communicate here. Okay, I don't see her. So this was set for a show cause today. And Mr. Gardner, since Ms. Holm is not present, what relief are you requesting?
Your Honor, we'd ask that the court authorize a bench warrant. $500 cash bond would be fine.
Okay, I'll go ahead and do that. Again, this is file 093193GC Munson Medical Center versus Holm. And it is now 11:12. The defendant has failed to appear, and Mr. Gardner is here on behalf of Munson. So it'll be a $500 cash bond, and we'll let you know when we catch up to Ms. Holm, okay?
Very good. Thank you, Your Honor.
All right, thank you. Let's go back to Mr. Rossiter. Are there any other quick matters as far as the other preliminary examinations today, either on Mr. Fox or Pruitt?
I believe Mr. Fox is going to be a waiver.
Is that correct, Ms. Claxton? You're anticipating a waiver?
That's correct, Your Honor. And then we had one bond issue we wanted to address.
Okay. And what about Pruitt? Do we know anything about Pruitt?
Nothing, Your Honor. I have not heard from him. I didn't hear anything at the probable cause conference. I believe at the arraignment, he had indicated he was going to retain his own counsel. I have heard nothing from any type of counsel in that matter.
Okay, is Bradley Pruitt present today? Okay, not seeing him on the line. Let me see here. Do you have witnesses here today, or I'm assuming you held off on that because of the attorney issue?
Correct. I held off. I have no witnesses for that case.
All right. And any problems with service in this case that you know of, Ms. Stocking?
I'm sorry, which case are we talking about?
Oh, we're talking about Bradley Pruitt. It's scheduled for a preliminary examination.
That was in his case. I just want to make sure I was looking at the right one. The last he was in court, he was arraigned on the 6th of July. He indicated he would represent himself, but reserves the right to request a court-appointed attorney. And that is the last we've heard from him.
Okay, well, apparently,
and his notice to appear did not get returned to the court.
Okay, so I'm not aware of any notice problems. This is a serious felony case, assault with intent to do great bodily harm, less than murder, or by strangulation. My inclination is to enter a bench warrant with no bond. Mr. Rossiter, anything additional for the people?
No, Your Honor.
All right, so that's what we'll do. And when we catch up with the defendant, then we'll set it for a hearing to determine whether he wants to go ahead by himself. It doesn't seem to be working out so well for him so far. So we're expecting a waiver on Mr. Fox and then a hearing on Wiltsey. Why don't we take up the waiver with Mr. Fox and then we'll go back to the hearing on Ecker. And I'm sorry to delay things, but trying to be efficient here with everyone's time. So this is file 213157FY, People versus Davy Wayne Fox Jr. And Mr. Fox, can you hear me okay? I had to mute you there for a minute because of noise coming back from the jail. Can you turn on the volume there? There should be a remote control.
Your Honor, Mr. Fox is in custody.
Oh, I'm sorry. What is your name, sir?
Davy Fox.
No, the gentleman in the jail.
He's muted.
Now you're unmuted. You're fine. What's your name, sir?
Mr. Wiltsey.
Thomas Wiltsey.
Oh, you're Mr. Wiltsey. Okay, I'm sorry.
Yes, sir. No, you're fine.
Okay, so let's go to the Fox case then. So Ms. Claxton, you've advised your client to waive the preliminary examination today, is that correct?
That's correct, Your Honor.
Is that based on the representation there be some sort of offer made?
No, Your Honor.
Okay, so Mr. Fox, you've discussed this with your attorney. She's advised you to waive today, and is that what you want to do?
Yes, sir.
No one's used any threats or force or coercion to get you to waive your right to a hearing, and you haven't been promised anything to get you to waive a hearing today, have you?
No, sir.
All right, Mr. Roster, are the people agreeable to the waiver?
Yes, Your Honor.
All right, do you have the paperwork?
I absolutely do.
Oh, and what's the next
would that be a pretrial date in circuit court? What kind of a
Yeah,
date? Okay,
pretrial.
August 9th at 8 a.m.
All right, so the defendant is bound over on the charges in the complaint to appear next on August 9th, 2021 at 8 a.m. And that is for the circuit court pretrial conference. You had a motion regarding bond, Ms. Claxton?
Yes, Your Honor, thank you. It's my understanding that at Mr. Fox's arraignment, it was ordered that he have no contact with his child. The basis for these charges are Mr. Fox allegedly not following a parenting time order in family court. There are no allegations of him harming his child in any way. I guess we're looking for the no contact order in this case to be lifted and to let contact with his child be determined by the family court order.
Mr. Roster, what's your position?
We would agree that that would be appropriate, Your Honor. This stems from a violation of a family court order in a custody dispute. I think family court would be the
okay, well, we'll go ahead. We'll go ahead and do that.
Terms.
Okay, sorry to interrupt there. Were you finished, Mr. Roster?
Yeah, I was just saying, I think they would be better suited to set the terms of contact between Mr. Fox and the child.
Okay, so we'll go ahead and do that with the agreement of the parties. So the no contact as to the child is lifted or not lifted. It shall be in accordance with the orders of the family court. All right, let's go to the circuit court arraignment. Ms. Claxton, have you advised your client of the nature of the offense and maximum penalties?
Yes, Your Honor, we'd waive a further reading. Mr. Fox would stand mute and we'd ask that the court enter a not guilty plea on his behalf.
All right, I will enter a not guilty plea on the defendant's behalf, the defendant standing mute. And is there anything else we need to take up today on that case?
No, Your Honor.
All right, so you're all set for today, Mr. Fox. You'll need to abide by the conditions of the family court as regards any contact with your child, or that would be a violation of the bond in this case. You understand?
Yes, sir.
Okay, so you can sign off at this time, and otherwise the bond conditions are continued. And let's see, good luck with your case and so.
Thank you.
All right, so let's go back to the Eckers case, and then we'll be taking up the Wiltsey case as the last matter for
What
this
did we do
morning.
with Ms. Schaefer?
Ms. Schaefer. We do have another one here. Okay.
Ms. Schaefer was the person I wanted a breakout room with, Judge, if that's possible while you're.
That's right. Okay, so I'll put you in a breakout room, and
thank you.
We'll go back to the Ecker matter right after that. Ms. Schaefer, you're still there, correct?
Correct.
All right. You're going to get a pop-up on your device asking you to join the breakout room, so make sure you accept that.
Okay, thank you.
Yeah. All right, so let's see. Mr. and Mrs. Ecker, would either of you like to testify in this case?
My husband would, yes.
Okay, so, sir, could you please raise your right hand?
Right.
Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, sir.
All right, you can put your hand down. So what would you like to tell me about this? Oh, you just muted yourself somehow. there, if you could start over.
Okay, all those
Go ahead.
statements that, I can't remember his name because I'm Mr. Kenny stated, is not true. And I do have a witness here that was standing there when he came in the yard and started asking questions and didn't announce himself who he was or anything, but he wanted questions. And then he proceeded to say afterward that he was ordinance officer, blah blah blah, and then everything you can see from the road and all that. And he's like, well, we give 30 days. And I was like, well, obviously I'm still cleaning up and it's not going to be done in 30 days. He's like, well, we're not disputing it, and pretty much left the yard and had an attitude. He's like, don't get an attitude with me. I was like, I was just simply saying, I know I can't get it done in 30 days, but I'm working on it. And he's like,
well,
I was like, you have an attitude. And he just left, and no business card, nothing. I have contacted the township before to try to get the ordinance. I've also been to Antrim County Courthouse. They said they never sent anybody and tried to get the ordinance. And I've not got any paperwork except for to go to court.
Okay. Sounds like you're not denying that there are these tires, junk tires, and unregistered vehicles that are visible from the road. You're not denying that, it sounds like.
Not all those vehicles are non-registered. They do have insurance. And there's
how many are registered and how many are unregistered?
Two are registered with plate and insurance. There's only two it's not, and one I'm working on taking to a junkyard, and the other one taking parts out to fix the other one so I can get rid of that. And the tires we're working on a playground for the kids, and if I have to put up a fence or get a permit, and that's why I went to the court to see where I can put the fence and how far back or what permit and how much it costs so I can hide that. But none of those questions were asked. He got an attitude and left.
All right, who's your friend is that the guy in the back seat there with you? That's the witness you're talking about. What's his name?
Mike Carlskin.
Mike, how do you spell the last name?
It's Karlskin.
Carlskin. Okay, great. All right. Is there anything else, Mr. Eckers, that you want to testify to?
Nope, just
the dumpster.
We got a 20-yard dumpster that we've got and we have already filled, and we're trying to work on another one to get rid of stuff.
Okay.
We've only been there for the last 3 years and moving 4 or 5 different properties and trying to get stuff situated and get rid of stuff. It's been a little hassle with COVID and being 3 months behind trying to get it. And you got to call 3 weeks or 3 days in advance to 3 weeks to even get a dumpster sometimes,
Okay. All right. Well, I'm going to have Mr. Durman give him an opportunity to ask any questions he has. You will have an opportunity to call your wife or Mr. Carlskin after Mr. Durman's finished asking questions. Okay, so go ahead, Mr. Durman.
Mr. Eckert, did you indicate, I maybe misunderstood, that you didn't get any other written notices?
Yes, I never got any written notices, no card, no nothing besides court.
Oh, besides the court. Did you get the exhibits that I mailed to you?
Nope. I've only got a court thing to show up today. That's it. That's all I got.
Is your address 2291 North M88, M66 Highway, East Jordan, Michigan, 4927?
Yes, it is, but I don't get mail there. My PO Box 173 is where I get mail.
Did you ever attempt to contact the township regarding these violations?
Yes, I have more than once.
Who did you contact?
I went in personally, and I can't remember her name, but I personally went in and talked to somebody at township and said I was being harassed and I needed to know what the ordinance was and a booklet, which I never got received on that. I went into Antrim County to get the ordinance law. They said there was no ordinance and they never sent anybody.
The notices that are in the exhibit indicate that they were sent to PO 173 East Jordan, Michigan.
That'd be the mailbox, but I ain't received any of it except for the court date.
You acknowledge that there remains violations on the property?
Do you acknowledge? Do you understand? No.
Yeah, I understand that.
Let's talk about the tires.
Yes.
What do you plan to do with them? I didn't.
I'm building projects with them and sorting them out and for the kids and making swings and all that and dirt bike track and all that.
And where is this going to be?
At my house.
You
whatever, anything I need to have, if I can get that information, I'll do it to make it legit.
You indicated that you were thinking about putting up a fence.
Yep.
Leave a fence if you hide behind the fence from the roadway these items we're complaining of, that would be a permitted to do. You understand that?
Okay, yeah, I know. Yep, and I understand that perfectly.
When is your plan to put this fence up?
As soon as I can get I can go over there today if I can get the permit. And then I'll put it up this weekend.
Well, it'll take a few weeks to get.
Yeah, a few weeks to get the fence put up, but I can go over today, hopefully, and get the permit if they'll give me it.
Permit from who?
Antrim County or wherever I got to get it.
Please check with the county and with the township. I believe there's no permits required for a fence.
Okay.
Okay.
Okay. So on this, so you can put a fence up within 2 weeks?
Yeah.
Do you acknowledge, you do acknowledge talking to Mr. Kenny, is that true?
For a brief second, he never really acknowledged himself who he was or gave a card or nothing, got an attitude and left.
And since that meeting, you have received no notices from Mr. Kenny?
That's true.
Even though they were mailed to PO Box 173?
Yes, sir. And I didn't know anything about pictures of taking. He never mentioned that. So without my knowledge of any record of doing anything.
Clarify that, please. I misunderstood or it was garbled.
All the pictures that he supposedly stated that he took without my knowledge, and he never said anything about or gave me information about the ordinance at all. No information, not a card, nothing.
I believe an ordinance was, I'd have to re-clarify with Mr. Kenny on rebuttal, but I believe an ordinance was provided.
Nope, it wasn't even at my witness. He was standing right there when Mr. Kenny came up in the driveway, never announced himself, had an attitude and left. But no information or nothing, said it's fine. And that's it. That's all there was. And then we got a letter stating that we had to go to court. And that's all there was ever said. Done.
No further questions, Your Honor.
All right. Mr. Ecker, do you wish to offer any additional testimony based on Mr. Durman's questioning?
No, sir.
Okay. Do you care to call any additional witnesses?
Yes, sir. Yeah.
Okay. Who's that?
That's Mike Carlson.
Okay. So, Mr. Carlson, if you could raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
Okay, you can put your hand down. Go ahead and ask questions, Mr. Acker.
Were you present today that Mr. Kenny drove in the driveway and started asking questions?
Yes, I was.
Did he ever announce himself?
No, he did not.
Did he ever give me a card or anything?
No, he did not.
And then he left with an attitude.
Yes, he did, but he had an attitude prior to that.
And that's all I have, Your Honor.
Okay, Mr. Durman, any questions?
Telling us that he did not indicate he was a zoning or an ordinance enforcement officer?
No, sir, he did not.
Did he state what the violations were?
No, he did not.
Did he state why he was there?
No, he did not.
Did he tell you to contact the township?
No, he did not.
No further questions, Your Honor.
Okay, next witness, Mr. Ecker.
My wife.
Judge, could I interrupt real quick?
My wife wasn't
Oh,
there.
hey.
It's us too.
Okay, hang on just a second. Miss Stacking?
Mr. Connolly says he can't hear Ms. Schaefer. Do you have her muted in the breakout room?
Well, I did mute her myself, but.
I
Okay,
haven't
need
even
to
been to
deal
the
with
breakout room.
Oh, she's not been to the breakout room.
I had no
So,
message
let
to go
me-
there.
You didn't get a message. Okay, so let
No.
me try that again. We'll get Mr.
Thank
Connolly back.
I'm here, Your Honor.
Okay, for some reason, Ms. Schaefer did not get a message to get into the breakout room. So I'm going to recreate that and we'll try again. Ms. Schaefer, can you say something?
Yeah, I'm right here. It says
Oh, you
Andrea
know what?
Kine.
Okay, that's the problem because I think I have you in two different places and only
Well, I
one
have
of
no
them made it.
access to my phone right now, so I'm using a tablet at rehab.
All right,
Or an-
Mr. Connolly, what label are you using?
I just labeled myself with my name, Your Honor.
Okay, we'll give it another try. All right.
There it is.
Mr. Ecker,
Yes, sir.
no other evidence or witnesses?
I do have one more question. I do have a mud truck, which is there. Does that have to be licensed too? And I have another question of a plow truck, because one's a plow truck and one's a play truck. And then the other car, two are getting fixed.
All right, well, that's a good question for Mr. Kenny, but right now we're in the middle of a hearing, so let's save those questions for Mr. Kenny at another time.
All right.
Okay, so then I want to turn to Miss Ecker. Mrs. Ecker, do you have any witnesses that you would like to present, or do you wish to testify?
No, I haven't been present. The first I heard about all of this is when I got a notice to appear for court.
Okay, all right. Mr. Derman, do you have any rebuttal evidence or any other evidence you wish to offer?
I would like to recall Mr. Kenny, please, just to clarify.
All right, Mr. Kenny, are you still there?
Yes, sir.
Okay, you're still under oath, so go ahead, Mr. Derman.
Going to Dennis, I refer you to your April 7th notice of violation and what's stated therein. Who did you meet with on site?
Mr. Ecker.
Was anybody else present?
There was some other gentleman, I don't know his name or anything, kind of off to the side. I think they were working on something in the garage or something. I never got a name or anything.
Did you identify yourself?
Yes, sir.
And what did you say?
I tried to talk to Mr. Ecker about the blight ordinance and the infractions and what we could do about it. And gave him a copy of the ordinance, and I was pretty much told that it's been there longer than 30 days and it will take more than 30 days, and when they get to it, they get to it.
No further questions, Your Honor.
Okay, any questions for you, Mr. or Mrs. Ecker?
Sir, that is not the way.
No, any questions? No, there's no questions.
Oh.
Okay. All right. So, and I understand your testimony is different than that, Mr. Ecker. So, all right. Well, I think we're all set here. And Mr. Derman, you want to make any closing remarks?
Very short, Your Honor, on this, that the township has always worked with its property owners. They provide information, they give extra time if necessary, if they see improvement on the property. Mr. Kenny has not seen any improvement of the property. He's had an attitude from Mr. Eckert on this matter. Our aim is not to punish. Our aim is to get cooperation and fulfillment of the ordinance, compliance with the ordinance. And Mr. and Mrs. have not made little to no effort. Dumpster, I don't know where it is. We haven't seen it from the roadway on it. They have admitted violations. I'm asking the court to simplify it in cost and also impose a condition that they continue, if they're going to, with their cleanup, or put a fence up to screen it from view from the roadway and from their neighbors. That's it. Thank you.
What are the court costs?
I don't have any out of pocket, Your Honor, because it all comes through the court sends everything out.
Well, I should say, are you asking for let's see, the ordinance provides for,
Costs up to $500 plus court costs.
okay, but not attorney fees. So-
Doesn't say that, Your Honor.
All righty. Okay, and you're just asking for 1 day of violation on the date that's alleged, even though the ordinance would provide, if there's a continuing violation,
Your
that
Honor?
you could ask for additional. Yeah.
I will ask for, if it's in the court order, that they be given 2 weeks fine, 2 weeks to resolve this issue. Otherwise, we come back for a hearing and additional costs and fines would be imposed.
Okay. All right. So let's hear from the Eckers now. And Mr. and Mrs. Ecker, you can make a statement. Both of you can make a statement if you like, or one of you on behalf of both, however you want to do that.
Okay.
Yeah, we have, we would appreciate if we could get 2 weeks to get the fence up. We moved from town where we've lived our whole life and you have to have a permit to do anything in town. So we figured we had to have a permit, but we couldn't get information as to where to get one. But yes, we have no problem getting it cleaned up. We have been working on it. And
To the plow truck and the play
No.
truck, we need to know if it's.
but we'll contact the township as far as our recreational vehicles. But
Excuse me, will you contact Mr. Kenny, please?
yes, I will do that.
Okay.
All
What's
right,
his name?
Mr. Kenny, are you still there?
Yes, sir.
Yeah. What is the phone number they should contact you at?
It is 760-267-3470.
Thank you.
Okay, so at this point, I've heard the evidence and arguments, and now I have to make a decision. Now, the question isn't whether or not Mr. Kenny had an attitude or whether he dropped off a card or not. The question is whether there's been a violation of the ordinance and whether the defendants were given some notice of that. And in this case, I find that there's obviously a violation. The defendants aren't contesting that there are at least 2 junk vehicles visible from the roadway. One is being parted out and will go to the scrapyard. And there was no argument that there are also these tires that maybe there's some intent to use them in some way for dirt bike track or whatever it was, or a swing, tire swing, but that hasn't happened, and so they are obviously scrap tires until they're put to some use, and they are visible from the roadway. So there's no doubt that there's a violation. With regard to whether there was notice given, I find it incredible to believe that Mr. Kenny came to the property and didn't give any information about why he was there. He was just a guy with an attitude who showed up in the yard. And so that is so far from my experience with how ordinance violations occur. The compliance officer is there to get compliance. They usually don't start out with a ticket. They just want to get some sort of compliance. And so I do find that the appropriate notice was given. And in fact, there are, I can't remember if it's 3 or 4 written notices that I have as exhibits that were introduced today, and there's no reason to even prepare a notice if you're not going to provide it to the defendant. In addition to that, there's the fact that these tickets were written back, let's see, well, they were written on 6/15, and apparently, you know, we're 30 days past that, and nothing has been accomplished. I'm not sure what the purpose of the 20-yard dumpster is for. There was no testimony about other trash. I don't think you can just put junk tires in a dumpster and get rid of them that way. They have to go to a special place that takes junk tires. And so, excuse me, this is the time for the ruling. So I'm not here to take additional testimony or arguments, okay?
Okay.
So so I do find that there is a violation in both cases, and this is what I'm going to do. I think the township has been reasonable in trying to work with you and try to get compliance. And frankly, I believe Mr. Kenny when he says that you said, well, we'll get to it when we get to it, and kind of blew him off. I'm going to mute you at this point because, again, I'm not here to take additional testimony, and you're out of order trying to speak over me. So anyhow, this is what I'm going to do as far as the resolution goes. I am going to, because of the voluntary non-compliance, I am going to impose a fine of $500 as to each ticket. And I'm going to also give the defendants 2 weeks to resolve the issue, either by taking care of the additional trash or by putting up a fence that adequately shields the trash from the highway. That would have to be in compliance with whatever other ordinances Jordan Township might have, or the county for that matter. If the matter is resolved to the satisfaction of the township, I would be willing to reduce those fines to $50 each. Okay? That means you can either put your money towards a fence or cleaning up the mess, or you can pay it to the court. It's your choice. Okay? And because it's if it's a continuing violation after those 2 weeks, it sounds like the township is willing to write more tickets, and you can be fined up to $500 a day for an ongoing problem. So you need to take this matter seriously, the township is, and you need to work with them. Anyhow, we're all set for today. Do you have any questions about that, Ms. Stockey?
I am all set, I think.
You're all set? Okay. Mr. Derman, do you have anything additional?
Nothing additional, Your Honor.
All right, we're all set for today. Feel free to sign off at this time.
Thank you.
All right, we're going to go to the preliminary examination now, and People versus Thomas Ethan Wiltsey. That's file 213151FY.
Your Honor, can I ask one quick question?
Yeah.
Do you want to do the preliminary exam, or do you want to do this?
PV.
Yes.
Okay. I forgot. We've still got a PV hanging out here. So, Ms. Schaefer, Mr. Connolly, have you had an opportunity to speak? And what does Ms. Schaefer wish to do this morning?
Thank you, Your Honor. We have had an opportunity to review the alleged violations as well as the recommendation from the probation department. Ms. Schaefer has indicated to me that she wishes to waive the right to a hearing and admit responsibility for violations. We do have some updates to the report for Your Honor as far as the recommendation is concerned.
Okay, well, we'll get those in a minute here. So Ms. Schaefer, is that correct? You want to plead guilty to the violation? Ms. Schaefer, can you hear me? Oh, you know what? Well, I don't think she's in the breakout room, no. Ms. Schaefer, can you hear me? For some reason, I can see you responding, but I can't hear anything you're saying.
Headphones.
Can you hear me, Ms. Schaefer? Okay, again, I can see you responding, but I can't hear you. All right, at this point, what I'm going to ask you to do is to call in, log off, call in, and give the meeting ID number. Ms. Stocking's going to give you those, the numbers here. So have a pen handy. You ready? Okay, go ahead, Ms. Stocking.
The number is 646-876-9923. And then it will ask you for a meeting ID, and that number is 242-305-0413.
Okay, and we'll wait for you to come back on the line. But while we're waiting for that, I am going to go ahead and get started with our preliminary examination. So again, this is People versus Wiltsey, and Mr. Connolly is here on behalf of the defendant, Mr. Roster for the People, and this is the date set for preliminary examination. Are there any issues we need to take up before we get started with the testimony, Mr. Connolly?
No, Your Honor, this is going to be held, so we would ask to proceed with holding it today.
Mr. Roster, any issues?
Yes, Your Honor. I don't know. I don't see my witness. I see one witness, Trooper Reska, who is not the primary witness for today's purpose. I think
I have someone on the line. It says, "Fight, Dad, fight." Who is that?
Your Honor, that's me, Anthony DePeel. I'm here just waiting on a other case, taking care of my kids. I'm in the afternoon. I'm just signed in.
Oh.
Yeah, I gotta get on.
Okay. So you're not here on this case then, Mr. DePeel?
Not at all, Your Honor.
Okay, and then I've got another person on the line at 231-651-9062. Who is that?
Renee Schaefer.
Oh, you're Ms. Schaefer. Okay.
Correct.
Okay, so you don't have the primary witness here today then, Mr. Roster. Are we going to be able to proceed with a preliminary examination?
Well, I spoke to her yesterday. It was my understanding she was going to appear, and it's, you know, I could put Trooper Reska on the stand, and I think I could, because this is a primarily a property crime. Most of it can be done with hearsay, but the defense wanted to hear from Brittany Bradley. So I would just assume with that concern that they have, hear her testimony as well. So I guess I'd see if the court wants to hear from
All
Mr.
right.
Connolly.
So, Mr. Connolly, what's your preference at this point?
With that knowledge, Your Honor, can I speak to Mr. Wiltsey? Just, I want to make sure I relay his desires to the court.
Okay, that sounds like a good idea. So, just a second. All right, Ms. Schaefer, we're going to have to wait for Mr. Connolly to get out of the breakout room now. So hang on. Okay, thank you for logging back in, and I'm sorry you're having some technical issues there.
This one?
The Source One Capital at 210. It says SP. I've never seen that before.
Land contract.
Oh, that's land contract. Okay.
That's me. I'm right here on the other side of the fence.
Okay, well, I thought maybe that was Mr. Connolly coming back, but it says Anthony D. Who is Anthony D? What hearing are you here for?
Matthew versus DePeel, Anthony DePeel, Your Honor. I'm just logged in the background. I'm actually sitting here taking care of my kids as I'm waiting for our hearing to come up this afternoon.
Oh, okay. So you're Mr. DePeel then, okay.
Yeah, my son just knocked my router off for a second.
Oh, okay. Well, you know, the hearing's not till 1:30, but it's always good to check in and make sure that your technology is working. So it is working fine.
11:15.
Wait, 11:15?
Yeah,
I have it at
here.
1:30.
And also, Your Honor, you wanted to make sure I was fully prepared for this case, and I was.
Yeah.
And I just wanted to make sure that you got the paperwork that I dropped off at the Antrim County Building drop box. I was directed by the county clerk if there was any paperwork to submit it there, and I did, in a big brown paper envelope with your case, name and the case on it. I know it's a big pack of papers, yet it is my case.
Yep. All right. Well, let me just take a look here and make sure. While I'm doing that, I should check to see, is the plaintiff here on that case, Michelle Matthey?
No. To my knowledge, no.
For some reason, on my docket anyway, it says this is at 1:30. Do you want to see?
That's very interesting. Mine says, it's very different. Mine very clearly says 11:15.
Huh.
And if your packet was 21 pages long, we do have that in the system as of the 20th of July, and it's marked as an exhibit.
Thank you. That is it.
Okay, so for some reason, we've got one docket that says this was scheduled for 1:30. What does the notice actually say, Ms.
I'm going to look
Starkey?
at that.
And the other says 11:15.
1:30.
1:30,
The
okay.
notice says 1:30.
And your notice says 11:15, sir?
Yes, I received two. And every time
Yes.
I've been notified, I've always received two because it seems like they changed it at last time.
The notice from 7/17 says 2. The notice for today says 1:30. But that's very interesting because it's not on the calendar.
Okay, well, there was some confusion with that. Do you have any difficulty being here at 1:30 instead of 1:15?
No, Your Honor, I am at the court's disposal today.
Ah, okay, that's what I like to hear. So if you like, you can log off because Ms. Matthey's notice says 1:30. And so that's when I would expect her to appear, and she's obviously not here right now. So,
All right, I will
so
do that, Your Honor.
just log in the same way at 1:30, okay?
Will do.
All right, we'll see you then. Okay, I see that Mr. Connolly's back. We'll get the jail back. And as usual, it takes about a minute or more. to get the jail back in.
Your Honor, just for the court's benefit and for Mr. Rossiter's benefit, my client has indicated he's willing to stipulate to an adjournment so that the witnesses can be subpoenaed. And this time he is asking that we set in-person preliminary examination. That would give the prosecution time to get the subpoena served, and then we can have these people appear in person at the courthouse instead of trying to work on Zoom.
Okay, any concerns about that, Mr. Rossiter?
None at all, Your Honor.
Okay, so that's what we'll do. This will be set for an in-person hearing on, is there any reason August 3rd or 4th will not work?
I think that's enough time, Your Honor, as long as the subpoenas can be served. I don't know what time Mr. Rossiter needs to subpoena folks.
I won't be available in the afternoon, Your Honor, on the 4th. I have a previously scheduled appointment. It could be done in the morning.
So let's see. Do we have any other prelims scheduled on that day currently?
So you have 2 prelims that day at 11. And that's, other than that, you have a 9:30, a 9:45, and a 10:45 at this point.
Oh, that's it?
Right now.
Okay, because today was pretty busy, and if it was like that again, I would be hesitant to do that. But
I don't know if the 18th is too far out because Mr. Wiltsey is incarcerated, but
yeah, I think so. Let's go ahead and schedule this. Now, here's the next question. Are we going to have both Zoom and this in-person hearing? And do you see any problems with that?
I think it could be tricky, but I think that the tricky part will be if Mr. Connolly has other events that day that are being noticed via Zoom, he will just be appearing from the courtroom rather than on Zoom. That's the only thing I can think of.
Okay, well, let's go ahead and give it a try. Yeah, go ahead, Mr. Connolly.
So I did attempt to, you're thinking about the 3rd. I am the MIDC attorney in Antrim on the 3rd, and I found out yesterday.
No, actually it's the 4th.
Oh, the 4th. Okay.
I might have said the 3rd because for some reason, I keep thinking it's the 3rd that we're here next, but it's the 4th.
All right. And Mr. Rossiter is available.
Good morning.
And Trooper Reska, are you going to be available on the 4th at 11?
That shouldn't be a problem, Your Honor.
Okay, that's okay. Your Honor, right now.
All right, and Mr. Roster, if you have any difficulty getting the victim here on that date, then just let us know as soon as possible. We'll set it for another date, and we will try to do it as soon as possible since Mr. Wiltsey is incarcerated. Are there any other issues we need to take up today?
Yes, Your Honor. Mr. Wiltsey is incarcerated in the Grand Rapids County Jail, just so we're bringing him home. And he is incarcerated there until October 29th, based on another matter that he was sentenced on.
Okay, so we'll need to have him writted to the Antrim County Jail for the hearing. And any other issues?
I don't believe so, Your Honor.
Mr. Roster, anything for the people?
No, Your Honor, thank you.
Okay, well, we're all set for today then. And Mr. Wiltsey, we will see you back here on August 4th at 11, okay?
Thank you. I appreciate you all.
Sure. All right, and thank you, Trooper Reska, for being present today, even though there was no hearing. And let's see. Oh, Mr. Connolly, we still got the PV on Miss Schaefer. So I had to mute her. I was hearing sound like a cell phone conversation going on or something. But anyway, Miss Schaefer, could you please unmute yourself at this time? Oh, and Mr. Wiltsey, you can let the jail staff know that you're all set for today. Okay.
Okay. Thank you.
All right, Miss Schaefer, are you still there? I got you muted right now, so please unmute yourself. Well, now I can't get Ms. Schaefer back.
Oh.
There she is. Okay, Ms. Schaefer,
There
can you hear
I
me?
Yeah, I can hear you.
Okay, so anyhow, so is it true you want to admit to the violation in this case?
Yes.
And you understand that any violation of your probation could result in your probation being revoked. You could get up to 93 days in jail minus credit for time served. Do you understand that?
Correct.
Okay. And no one's forced, threatened, or coerced you in any way to get you to waive your right to a hearing in today or promised you anything, right?
Correct. Correct. Nobody.
Okay. All right, then. So is it true you were placed on probation May 26th, and that was for an impaired driving? And as a condition of that probation, you were not to consume or possess alcohol.
Correct.
And you were to take PBT tests to verify that you weren't using alcohol, correct?
Correct.
And on June 11th, 12th, 20th, 22nd, 23rd, 25th, and 26th, and 27th, you did in fact consume alcohol in violation of your probation.
Correct.
And you missed a morning preliminary breath test on June 13th as well. Is that correct?
Correct.
All right, then. To those violations, how do you plead?
Guilty.
All right, I'll accept your plea, find it's voluntary, accurate, and understanding. So, Mr. Connolly, what you said you had some additions to the report to make. What are those?
I did, Your Honor. Ms. Schaefer has completed the 12th and the 13th. She's currently in the Phoenix Hall in Traverse City, where she was transferred to on the 14th, and she's there for the 28-day program, Your Honor. I believe she's coming to us from there on tablet today. So she's certainly taking the right steps here to look into her health and her future. And I think the recommendations taken in conjunction with the fact that she's already in rehab are a good recommendation, Your Honor, and probably would be best for everybody if Your Honor were to order that and she were to follow through.
All right. Ms. Schaefer, is that correct? You're coming to us from Phoenix Hall this morning?
Correct.
And when did you arrive there?
Well, I did detox on the 12th and the 13th, and then I arrived on the 14th.
Okay, and you're there, and it's supposed to be a 28-day program, correct?
Correct.
So that would be, well, let's see, 16, 17, about August 11th or 12th, maybe. You'll be there. And how are things going?
Really good.
Okay, glad to hear that. And if I keep you on probation, do you think you can follow the program, not use alcohol, and follow all the aftercare recommendations?
Yes, sir.
Okay. Mr. Roster, anything for the people?
No, Your Honor, thank you.
All right, Ms. Stanichuk, any additional recommendations? I don't know if you were aware of the, well, it looks like you were aware of the residential treatment. So anything else?
No, I was aware of it, and I do have verification that she's there, so I don't have anything further.
Okay, good. All right. Well, I am going to follow the recommendations in this case. I think they're appropriate and in the best interest of both the defendant as well as the community and public safety. So I'll order that you complete your residential treatment and follow all aftercare recommendations that they have. and sign any releases so we can verify treatment, and those recommendations can be sent to the probation office. You're to attend 90 12-step meetings in the 90 days after you're released from residential treatment. The reason for that is you need to be heavily invested in those 12-step meetings. You need to have people you can reach out to you know, when you're about to pick up a bottle, and they can talk you off the ledge, so to speak. Okay. There'll be an additional 45 days held in abeyance. So I'm not going to order any additional jail time for the violations at this time. I just want to see you get better, but if not, we'll consider additional jail time. Otherwise, we'll continue all other conditions of probation. And since you're in this residential program, I'm going to waive the additional court-appointed fee. Okay, so you're all set for today? Yeah. Okay, well, good luck to you, Ms. Schaefer. I'm glad you're there and you're taking some positive steps to try to do something about this, okay?
Thank you, Your Honor.
All right, feel free to sign off at this time.
Okay, thank you.
Thank you, you too. Thank you, Mr. Connolly and Ms. Standish, and have a good afternoon, Mr. Rossiter.
Thank you.
I think that wraps us up for the morning, correct?
Yeah.